My name is Chuma Chinye, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. My name is Chuma Chinye, and I am your family lawyer. It's my job here to help you navigate the world of family law and to bring to your clear understanding things that seem shrouded in legalese. Today, we are continuing our discussion on will, and we will delve into why it's imperative to make a will. We'll talk about when you should make a will. We'll flip the coin and talk about the consequences of not making a will, which is technically called intestacy. First, let's talk about the imperatives of making a will. In other words, why should you make a will? A will is not just a document for the wealthy. It is a critical tool for anyone who wants to ensure that his or her assets are distributed according to their wishes when God calls them home. Without a will, the estate law of the state in which you are domiciled decides what you get. The kind of marriage you contracted decides what you get. Without a will, the estate law of the state in which you are domiciled decides who gets what from your estate when you pass on. And this can lead to unintended consequences and disputes amongst your loved ones. When this happens, your custom might decide what happens to your family. The kind of marriage you contracted might decide what happens to your family. And I'm not sure if this is what you want to happen. Today, we'll tell you why it is inevitable for every person, every male, every female, rich, poor, old, or young, to make a will. Making a will is essential for Nigerians, just like for everyone else world over. And it is to ensure that their assets, their properties, and their wishes are respected and carried out in the manner they desire after they have passed on. I'll give you a few compelling reasons why you should make a will. I'll just break it down in simple language so that you can make that will whilst you still can. The first and perhaps most compelling reason is that you will avoid what is called intestate succession, which is dying without having a will. That is, you just died. That is the end of you. Nothing, no legacy to speak for you. And when this happens, as I've just told you, it is a law that will give you heirs, will determine who your successors are. And this may not align with your wishes. Now, very closely connected with this is that if you don't make a will, you fail to protect your loved ones, the people God gave you an assignment to protect throughout your lifetime, then you abandon them upon your death without stating how you would want them to be taken care of. Now, a will enables you to appoint an executor. That is to say, to name somebody you think is best suited to represent you in your family life and your properties when you are gone. That person will take care of your children, ensure that your debts are paid, ensure that your school fees are paid, and that your properties do not go to waste. And on top of this, the will helps you to prevent squabbles, conflicts, disputes, which are easily avoidable if you simply state in your will that my first son gets this, my second daughter gets this, and my wife, whom I love so much, gets this. Of course, a will enable you to ensure business continuity. If you are a business owner, what is your succession plan? You can state it clearly in your will so that your business might continue to run after you're gone. Of course, you have minor children. You may have minor children for whom a guardian is needed. How do you protect them if you don't have a document that states clearly how this should be done? You may be somebody who loves to care for widows or for orphans. You did so all through your lifetime. You can continue to do so even after you're gone through your will. And of course, when you've done a will, you've stated clearly what should happen. You have peace of mind. You know clearly that if the time comes, your family will not suffer. Of course, for those who are ardent practitioners of religion or custom, you can use your will to specify that you want your will, your estate to be distributed according to specific kinds of custom or faith. You may want to specify how you should be buried. You want to be cremated. You want to be buried on the same day you die or a week afterwards. You can specify this in your will. And so making a will is an important and responsible decision for every adult to make. You fulfill a biblical injunction to cater for your family. If you're a Muslim, you fulfill that same injunction. If you are simply a morally upright person, you don't go to church, you don't belong to any religion, you know in your conscience that you have a duty to your family. You do that very well when you're in good health, when you're alive. But your life is not in your hands. You need to do things, take steps to make sure that if something happens, if tomorrow doesn't come, things might still go on in your family smoothly. Having said this, Let's now highlight the challenges of not making a will. Irrespective of your type of marriage, whether you have a traditional, a civil, or religious marriage, a will ensures that your assets are distributed according to your wishes and provides for your spouse and your children. This cannot be overemphasized. Of course, I know that what agitates most minds is, well, I'll make that will tomorrow. It's not yet time. When I do this or when I do that, or, you just leave it there. But when truly should you make a will? Let me burst your bubble. It's not later. It's not when you buy or build a home. It is not when you buy that car you dream of. It is not even when you get married or when you have children. It's not until you attain the mature age of 40. It is not tomorrow that you should make your will. Unless you just finished a family meeting with the Almighty God, where He told you the exact date and time, and perhaps place and mode of your death. The time to make your will is now. Yes, right now. I urge you to pick up that phone and book a consultation with a family lawyer, or go to our website to access our free guide on how to make a will. It is not an expensive thing to make a will. Get it done now. There is something you need to know up front. I'm not just trying to persuade you to make a will. There are consequences if you fail to make a will. First, your government, your property, inevitably might become that of property of the government to the extent that it's now left for the law of the state where you live or your custom to determine what happens to your family. And if your family cannot be found, perhaps they live in the UK or in Canada or in Australia, the estate will fall to the government. Now, we'll give you some specific scenarios that very common when you die without a will. If you married under the Act, you know that one we call white wedding, court wedding, church wedding, but you died without making a will. Or if you married under Islamic law and died without making a will, or if you married under traditional law and custom and died without making a will, or if you didn't marry, you were a reverend father or sister, or just couldn't find someone you liked enough to call a wife or husband, and then you died while still searching, the law will determine who inherits your estate. With these scenarios in mind, let's flip that coin I promised you at the beginning of this podcast. What happens to your property, your money, your wife, your children, your relations, if you die without making a will? If you die in this country without making a will, you are said to have died intestate. That's your nickname, intestate. You died without making a will. And when that happens, it is the administration of estate law of the particular state where you are domiciled that will determine how your property is managed or shared posthumously, that is when you're gone. Most administration of estate laws specify the order of inheritance if you are married under the Act, under the Marriage Act that is, and then you died without making a will. Usually the order of inheritance is your spouse, your children, your parents, and then your siblings. In that order, in other words, your spouse should get a significant share, your children a significant share, and then if you still have parents, but if you have a spouse, you don't have children, in that order, that's how the law specifies it. If you wish to know more about this, you could possibly consult a lawyer or visit our website for more information. Of course, this state of affairs leaves consequences for the people who have just named, that is to say for your spouse or your children. And generally, they may not get as much as you may have desired them to get, or they will not get in the measured quantum you would have decided in your mind that you want them to get. Now, the law determines the ratio and who gets what in specifics. But you can prevent this by writing it down by yourself, getting two witnesses to sign it, that what you have written. If you want to be sure that what you have written is done properly in accordance with the law, talk to a lawyer. Of course, we're all too familiar with the potential conflicts of dying without a will. Traditionally, it's been a source of pain and anguish and regret for many widows. Particularly, I do know in the southern part of Nigeria, there have been many cases of a man dying and the wife is forced out of the family home with her children. And relatives, mindless relatives, take over their estate because it is said under their custom that women, God forbid, cases where the woman didn't have a male child. This have been, unfortunately, many states have taken a lot of action on this. Laws have been passed. I know in Rivers State recently, the former governor of Rivers State caused a law to be passed that ensured that female children could inherit from their parents. These are needless conflicts. These are needless pains that you leave for your family. As a man caring for your family, who cares for his family? As a woman who cares for his family, for her family, it's important that you take steps now, very easy steps, that making a will,
to ensure that they don't go through those pains that you read of. It may seem far from you, but it's not too far. It's not too far. Those siblings or relations that you think are the best may become an albatross for your children. I don't know how the courts will decide the Herbert Wigwe matter, but you can see what's going on in that family. He's dead, the family is fighting. But I think that because he made a will, because he created a trust, those issues will be more easily determined and resolved. Otherwise, some persons would have been left in quandary. So if you're married under the Act, as we've just told you, the law specifies how your estate will be distributed if you died intestate. If you did not marry according to the Act, you married under customary law. The customary law of your place will determine how your estate is devolved to your children and to your wife and perhaps to your relatives. If this happens, the saving grace perhaps today is that we know that those customs must not conflict with our laws, must not conflict with equity, natural justice, and good conscience. But then the family, your wife and children may have gone through untold hardships before the law takes its course. Why don't you prevent this from happening? Then, of course, if you are married under Islamic law, Sharia law would determine what happens to your estate. Fortunately, the Sharia law is quite specific about who gets what. But still, it is still best. You may have a preference that you want the kind of thing, you want a particular child for certain reasons to get a specific part of your estate. This will not happen under Sharia law. The law will just follow what it is if you don't make a will. And then if you're not married, we told you in the last episode that if you're not married, the case is probably worse because most laws regarding intestacy do not quite know who you are. Your property will go to your relations in a manner that you have no say in. Even that your uncle that you despise might be the one to take over your estate. Your father's wife who maltreated you might be the one to take over your estate. So be careful. If you're not married, make a will. Make a will. Specify how you want your estate to go. And then you don't have an appointment with God. So you can't say because I'm 35, I will wait until I'm 40. Not quite. Now, before we leave this part of this conversation, let me bring up something that is quite common and quite painful. When you die without making a will, you have daughters. I have 3 daughters. You have daughters. You may leave them with limited chances of inheritance in some societies. So if you have daughters, you have even a more compelling reason to make a will so that they don't have to fight for your estate. One of the stories we'll tell you shortly involves this kind of situation where an uncle thought that the daughters of his brother with whom he owned a joint property should not be entitled to inherit his estate or his part of that estate because they were women. But now let's tell you a quick story involving the family of Akinobi, which occurred sometimes in 1997. That was when that case was decided in court. A prominent Lagosian named Rufus Gbadebo Akinobi died and left behind a story building in Okitipupa, which he had rented to Wena Bank. Sadly, he didn't leave a will, plunging his widow Grace and their 5 children into a legal nightmare. Rufus's brothers, sensing an opportunity, smelling blood, quickly applied for the letters of administration to be issued to them to control the estate of their brother, thereby sidelining Grace, the surviving spouse of Rufus. But Grace was determined to secure her children's future. She contested the grant, arguing that she should at least be a co-administratrix, I hope I got that right, to represent her children's interest in her husband's estate. The probate registrar, for some reason, initially sided with Rufus' brothers, granting them letters of administration to the exclusion of Grace. But she didn't give up. She initiated legal proceedings. She claimed that the letters of administration granted to Rufus' brothers were null and void. Grace's journey was fraught with challenges. She had to single-handedly support her 5 children through tough times, often resorting to selling fruits and vegetables on the streets of Lagos to make ends meet. Despite her best efforts, Rufus's brothers dug in. They contended that she had no right to administer her husband's estate, arguing that under Yoruba customary law, she was part of her husband's estate. She was a property to be counted, and that they had the right to own her and the properties her husband left behind. Sad. Very sad. Well, the case took a dramatic turn for good when Grace's application for interim relief was granted by the trial court, ordering the Wena Bank to pay accrued rent to the Administrator General for the children's maintenance. You won't believe this. The Rufus brothers went to the Court of Appeal to block the education of their brothers' children, the height of greed and heartlessness. Of course, the appeal was dismissed. Grace was acknowledged as, at the least as a next friend for her children, somebody who was entitled to protect her children by using her husband's estate to look after her children. This judgment highlights that justice must prevail over greed, over avarice, and wickedness. But when someone dies without a will, these are the kinds of things that will happen because you don't leave clear instructions. The families can be embroiled in legal battles, with rightful heirs sometimes losing out. Grace's case illustrates how intestacy can lead to dispute, to delays, financial hardship for the surviving family. Fortunately for her, she had the grace and the courage to pick up the mantle and fight her battle, and then she prevailed. I mentioned a little earlier about some wicked person who thought that the daughters of his brother should not inherit his share of a joint property. Now, I'm going to just break it down for you in a summary what transpired and led to this issue in Enugu State. The property in dispute belonged to a certain Simon Onunze Ugbene. He owned a property in Asata in Enugu and had two sons named Benjamin and Godwin. They were minors when he died in 1948. By 1961, the brothers had come of age and jointly renewed the lease, the state lease of the eastern region on their father's property, registering it in their both names. Tragedy struck during the Civil War. In 1968, Benjamin was killed during the war, leaving behind his wife, Cecilia, and their two daughters, Geraldine and Deborah. Cecilia, and now a widow, and her daughters continued to live on the property until Cecilia relocated from Enugu, leaving her daughters with their grandmother, her own mother, until her death in 2000. In 2008, Godwin, now a retired Air Force officer, with might and force, pushed out his brother's children from that property, claiming sole ownership of the property. He argued mischievously that under customary law, as females, they had no inheritance rights. Of course, Geraldine and Deborah were dismayed. They were shocked that a beloved uncle could do that to them. But they found again the courage to pick up the fight with him. And then they found out that he had gone behind them and altered the property land registration in the land registry by taking out his late brother's name and putting the property in his sole name. Fortunately, it was proven that his brother Benjamin had married his wife under English law, and that therefore customary law was not applicable to his estate. And so the ladies were restored to their father's property. Well, just imagine if at the time in question, way behind from now, the mother, it was shown that the marriage was under customary law, and somehow the ladies may have lost out of their father's property simply because their father did not make a will. If you own a joint property with somebody, please always make sure to make a will to specify what should happen to your share of that property. If it's a business partner, if it's your brother, whatever, whoever, make a will so that you don't leave a fight that is needless. You don't occasion losses that could be avoided on the people who come after you. The stories we have told you serve as a stark reminder of the importance of making a will to clearly outline the distribution of assets and protect loved ones from prolonged legal battles, from hardship, and from their destinies being altered. Because people have been thrown out of school because they cannot afford to pay school fees, even when their father left substantial sums in the bank and had properties that could have been converted into cash to train them. But wicked relatives pounced when he passed on. Don't be that wicked relative in any event. Don't pounce on your brother's properties. Don't push out his wife, even if he didn't make a will. But it is best if you make a will. You that is doing the pouncing, make a will. You that you have a lot of properties, make a will. You that you have just little or a joint property, please make a will.
This has been today's episode of Your Family Lawyer. It's been my pleasure bringing it to you. And I trust that you've learned something, because I too have learned something from it. Next week, we'll be talking to you about trusts, which could be an alternative to a will. And I do hope that you will join us then. But until then, please stay informed and be empowered. And by all means, be good to your family. One of the ways you could be good to your family is to make a will. Do it now. My name is Chuma Chinye, and I am your family lawyer.